Fire!
We're going to get into our next presentation here. I've got Matthew Butgoyne from Mcleod Law. Yes. And he's going to be laying down the law, letting you guys know about digital currency law here in Canada. And you actually have some experience in digital currency. You didn't just like jump in. You were talking. He's been around the block. So I'm going to pass it off to him and let him take it away. So give him a round of applause, everybody.
Thanks, everyone. I'll try to get comfortable with the microphone. Thanks for sticking around, because I know, last day of the conference, at the end of the day, I got bumped. I think I was supposed to speak at 1, and then I realized when they told me 4 that I realized I'm not too many people here. But this is a good crowd. Thanks for coming out. I love what Jan and Ross have done here, and the rest of the team. So yeah, my name's Matt Burgoyne, and I first got into Bitcoin in 2013. I was reading a website called The Leaf Daily, and they were talking about Bitcoin in conjunction with online markets, and I was like, "What? How does this Bitcoin work?" And I bought and sold some myself. Kind of got a taste of it, and then kind of just wondered like what lawyers are doing in the space. And in 2013, in Canada, there were very few lawyers that had anything to do with cryptocurrency. Some of them were out of Toronto, a few of them who were doing like gaming law, working for internet gamers and that, gaming companies, and so they knew something about cryptocurrency. Now, you go online and a lot of law firms help themselves as being experts in the field. I don't count myself as an expert. I have personal experience buying and selling not only Bitcoin but other cryptocurrencies, and I practice law. I practice corporate law and securities law, so I've been able to kind of tie that in with the work. I'm just here to kind of share some of my information with you, and I'd be happy to answer questions. I guess when I finish the presentation here. So we've got an agenda. Canada. Let's see here. There's a lot. Yeah, there's a lot of information here. I'll try not to drone on. I just wanted to talk really quickly. Number one, Canada's common law system. So when we say crypto law, what do we mean? Aside from the pre-published changes to Canada's Proceeds of Crime, Money Laundering, Terrorist Financing Act that actually mention virtual currency in the Act, we'll mention it when the changes come into effect. There's no other law in Canada that specifically uses the word digital currency or cryptocurrency. So we have, in Canada, we're under a common law system, so we have case law, we have judge-made law that takes into account precedent and effectively creates new law through judicial decisions, and those are legally binding, and then we have the statute. So until there's some more disputes in the area and some more cases brought to court regarding cryptocurrency, we don't really have a lot of clear guidance on how the existing law applies. I'm going to focus today on anti-money laundering law and securities law. And I was originally just going to talk about securities law, but the anti-money laundering law is going to be so important for anyone in the digital currency business. It is really important that kind of you guys get the basics and of what's coming, and I hope I convey that to you today. So I guess I start off here in 2014. Canada's Department of Finance, I think they realized that there was a hole in the legislation pertaining to money in Canada, and it did not contemplate virtual currency, as they called it. So there was something there. There was a method of storage of value that was being used in transactions and swapped and traded on, and the government in 2014 announced that they would be changing Canada's federal anti-money laundering legislation to account for cryptocurrency. So they made this announcement in 2014. We literally waited until June of this year when the federal government finally pre-published changes to the anti-money laundering regulations. They pre-published the changes and then they opened up a comment period for 90 days. And that comment period effectively expired on September 9th, this past September 9th. Is it a 9 or a 7? Well, let's just say 7. So there was a period of consultation that they wanted to have with the public, and the changes to the money laundering legislation is primarily going to affect cryptocurrency exchanges and value transfer services, although that term isn't really clearly defined in the pre-published changes. We think that pertains to like Bitcoin ATMs and other similar technologies. So it'll likely, okay, so the comment period's over, so now the government is taking in all of the comments that people have submitted, and probably see the legislation in final form come out in December 2018 or January 2019. And then it's probably going to take another year to actually come into effect. Probably not until early 2020. So we have some time to adapt and get familiar with these laws. So I've just got some background facts here. I guess what I'm going to focus on is something called a money service business, or MSB, and a money service business is any entity that transmits money in any form. Think a check cashing store, think a foreign exchange dealer, Forex, payday loan companies. These are all money service businesses under the Proceeds of Crime, Terrorist Financing, Money Laundering, Terrorist Financing Act. The government wants to lump those dealing in virtual currency as money service businesses. So they want to expand the definition of an MSB to include persons engaged in the business of, quote, dealing in virtual currencies, as that's going to be defined in the regulations. And that applies to domestic Canadian money service businesses and also any foreign MSB that's operating in Canada. So if you're a cryptocurrency exchange that's located in Tahiti, and you're doing business in Canada, the Canadian government is going to expect that exchange to follow Canada's anti-money laundering laws. So what are these pre-published changes that are coming into force in early 2020? What do they say? So there's a new definition of virtual currency in the regulations to this Anti-Money Laundering Act that I mentioned. Virtual currency is going to mean a digital currency that is not a fiat currency and that can be readily exchanged for funds, or for another virtual currency that can be readily exchanged for funds, or, quote, information that enables a person or entity to have access to digital currency referred to above. The interesting thing is they don't define digital currency. And that bolded B that you see is, it's interesting because that could mean a lot of things, right? That could mean login credentials to access digital currency. It could mean a wallet address. That's all information, right, that enables someone to have access to digital currency. So, my hope is that the feedback that the federal government got on this consultation period addressed the vagueness, and that it's very open-ended, right? We need to tighten that up a little bit, and my hope is that the government ends up tightening that up. Otherwise, I think there's going to be some confusion in regards to what exactly constitutes info that enables a person to access digital currency. So it's an expansive definition. It could be problematic. Note in A, it says not a fiat currency. Just trying to read my notes, but note that some countries have incorporated digital currency as their national currency. Barbados, Marshall Islands, Venezuela. So I think that's got to be addressed here. And so login credentials, wallet address for B, that could all be captured. And the Canadian Securities Administrators, as we know, they do view digital currency as a security in some cases. So rules in securities legislation could also apply to digital currency. We'll get into that in a bit here. So what are the obligations? Before I get to that here, So persons and entities that are dealing in virtual currency would include domestic or foreign MSBs, and they do mention value transfer services. We're not quite sure what that means, but we think it relates to things like Bitcoin ATMs. So responsibilities of a dealer in virtual currency. So same obligations as a money service business has currently. They have to put in place a compliance program. They have to appoint a chief compliance officer. They have to create a manual with policies and procedures, develop a plan for risk assessment and management, have a training program, ongoing review of compliance regime. There's ID requirements and of transactions of $1,000 or more for politically exposed persons. That's like heads of state or people that are influential in government. If those people are customers and they're dealing in 100 grand or more, you have to determine the source of funds. And my comment here is that I think this could be problematic when the source of funds in crypto, when the source of funds is crypto, especially with privacy coins like Monero and Zcash. There's ongoing monitoring and risk management. There's record keeping and reporting. You have to file large currency transaction reports. There's a lot of it's quite onerous actually, the reporting and data collection requirements under the legislation. You know, I asked, could this be a barrier to entry for some persons and companies dealing in virtual currency? Absolutely. There's a bit of a startup cost involved to get compliant, and then once you're compliant, that's all fine and dandy, but the key for the federal government FinTrack, which is the watchdog that polices compliance with the Act, the key is maintaining compliance and actually complying with your policies and procedures. So it's one thing to spend you know, thousands of dollars creating a bunch of airtight policies, but if you're not following those policies and you don't have someone in your company looking over your shoulder that's making sure that your entity is following the policies, FinTrack can come in and do an audit and it could be all for naught, right? So yeah, it does create a barrier, and I think you know, we need some clarity on those open-ended issues that I just mentioned. So that's it for the money laundering, anti-money laundering part of my presentation, and so we'll move on to cryptocurrency and securities laws. So in my experience, the major areas of law which touch on cryptocurrency, and I have kind of worked with clients in the space since 2013, 2014. It's been consumer protection, anti-money laundering, and securities law, especially with the advent of ICOs and token offerings and that. So there's two overreaching laws pertaining to securities law. There's a prospectus requirement and the registration requirement. So you can't sell securities in Alberta unless you have a prospectus. And if you're acting in the capacity as a securities dealer, you have to be registered as a dealer. And there's a bunch of exemptions to those requirements, and I'll get into some of those in a minute. But the primary rationale for securities laws is investor protection. So what is a security? It's actually quite a long laundry list in the Securities Act. It includes things that you might not think intuitively are securities. But you know, the whole mandate of the government is investor protection, so they want to include as much as possible. I've listed a few things here, and you know what? If you think about it, some of these might be might directly relate to cryptocurrency. Document constituting evidence of title or an interest in capital. You know, if you're an exchange and you hold someone's crypto, you're holding a document that's arguably evidence of title to someone's assets. Is that a security? The one at the bottom, an investment contract, that's the catch-all for in the definition of security for things that don't quite fit into the other categories, but when all of the facts and circumstances are taken together, you know, it is a security. Investment contracts exist where there's an investment of money in a common enterprise with the expectation of profit solely from the efforts of others. So this is derived from the Howey test in the US, and you know, you hear a lot about the Howey test in the digital currency space, and it's because some of these coins released in ICOs really are arguably investment contracts when everything's taken together, but it really depends on the facts. So when you're trying to analyze whether a native cryptocurrency coin or an ICO token is an investment contract, you have to apply the legal test, and then you apply the smell test. So you look at the facts, you look at the law, and then you just look at kind of everything. Just generally speaking, does it look like a duck, swim like a duck, quack like a duck, and then what do the securities regulators think? So they're going to look at all the facts taken together and apply the law. And if a reasonable person looking in thinks that would think that there's something's a security, the regulators might take that position. But fortunately, there is quite a bit of law and guidance on investment contracts, so we have some guideposts, but there hasn't been a lot of judicial decision in the area. So some of this stuff is still gray. And I know when it's just like every coin offering, every project is so different, and there's always like a subtle difference in facts. And so it's my job to look at the facts and historically try to come up with a clever argument as to why something is not an investment contract. Like if it's a native coin on a platform, fine, that's different. If it's an ICO, it's really tough to argue that an ERC20 token standard coin or token is not a security, but there are some very unique cases and some people who've come up with some really clever ideas. So as dry as this sounds, it is kind of a cool job in some ways, because I get to see these different projects and get to come up with some clever arguments on people's behalf. So there's been some guidance specifically on cryptocurrency that has come out from the Canadian securities regulators, and they and they kind of say this in other areas of law. It's not just cryptocurrency. 9 times out of 10, they say the token offerings they've seen are securities. Like surprise, surprise. If you're dealing with mortgages, the Alberta Securities Commission is like that. They kind of err on the side of caution, and it's up to an issuer's lawyer to kind of prove something to the contrary. And so I've come up with a list, and this is taken from some guidance that came out from the Canadian Securities Administrators recently on token offerings and securities law, and my own experience, and we can talk about this after in the question portion. So indicia that it may suggest that it's a security. If it's still in development, if someone is trying to raise money for R&D and ongoing legal costs and marketing, that's kind of a telltale sign. Like if there's no platform built, if there's no nodes, if nothing's happening, it's indicia that it may be a security. The expectation of profit is a tough one, because not all coins that carry an expectation of profit are securities. And sometimes it depends on how management's promoting it. Whatever it was that the last speaker had up on the screen, not Fitbit, but it was the exchange that looked kind of sketchy. Yeah, like I read about that on Twitter the other day, and I can't believe how audacious that is. How obviously they're pumping. It doesn't surprise me, but the regulators would just dive right into that. Like if that company was issuing out of Alberta, or that there were directors and officers related to that entity in this province, enforcement would be all over that. And I've seen, I've counseled clients through some enforcement actions, and it's expensive, time consuming, and it's not pretty. But so indicia that may suggest that the token or coin is not a security. It's not designed as an investment. Like I said, there's an underlying platform that exists and has utility. And by utility, I mean like utility in the sense that I think about it is you can actually do something with it in a tangible way right out of the gate. So there's a game, for example, that you can use it with, that you can tip players on, like some, I don't know, an electronic sports game, for example. There are things that you can buy with it. You know, I don't know, there has to be something tangible and not just made up for the sake of like giving it utility that exists. The token value doesn't depend on further development. Number of tokens is not limited. Sometimes if they limit tokens, the regulators will argue that it's just to inflate the price. So this SAFT, you might have heard of, Simple Agreement for Future Tokens. This is an invention by a lawyer in the States that I've met before, a guy named Marco Santori, who worked for some of the big firms in New York. So he came up with this idea, and it's taken from a similar concept. I think it was called, well, the word token wasn't in it, but this concept has existed in securities laws before. So the idea is that you do an initial sale of something that is a security. You raise money, usually from accredited investors, and then you use that money to develop the product that you argue is not a security after. So it's a two-stage process. The Securities Commission in this province has taken the view that in some circumstances, the secondary offering stage in a SAFT might not be a security, but again, it depends on the facts. So what does this all mean? We have existing laws that need to be considered and complied with, although the application of those existing laws to these new and novel ideas, it's not clear. It's still very gray, and we need case law, we need courts to resolve some of the grayness. And unfortunately, like, no one wants to be the test case where they get sued or whatever and ended up before a court and they set a precedent. But I think we need that in the space, and I think that's coming. If cryptocurrency or a token is a security, you have to file a prospectus or rely on one of the numerous exemptions. So accredited investor exemption, think if I remember correctly, high net worth individuals, you have to have at least $1 million in net assets, or you earn $200,000 before tax in each of the 2 most recently completed financial years. That's an exemption from the prospectus requirement. An offering memorandum, where it's like a mini prospectus, you draft that, you need audited financial statements, but with that document you can sell to a large number of people who don't have to be high net worth individuals. The registration issue in securities law is if you're in the business, quote, of dealing in securities, you could have to register your firm or your company as a firm in the firm category of registration. Or if you're an individual, you might have to register as a dealer yourself if you're in the business of selling securities. And that's called the business trigger, and has to be registered. So that's it. Yeah, I guess we can open it up for questions, and I'll do my best to answer. If there's something I can answer for you, I'd be happy to give you my card and follow up with an email. And if anyone wants copies of these slides, let me know, and I'd be happy to send them out. So, yeah.
I'm going to hop up and ask some questions as well. If there's somebody back there that can lift the screen, that would be fantastic, and we can take a few. Now, I had a few questions. I'm sure there's going to be a few questions out here, but I jotted 2 down that I just really quickly wanted to. We can take a seat next to the big Bitcoin bee. First of all, thank you very much.
Oh yeah,
that was great. So I had 2 quick questions, and then I'm just going to open it up to everybody here.
Sure.
So one of them, you're talking about money service businesses, MSBs, and needing to be an MSB if you're facilitating movement of money for people and exchanging of money. Now, does that apply to only those that are dealing with, say, Canadian dollars, or, for instance, let's say a company like Binance, and they I know they're moving into having fiat currencies, but they only deal in digital currencies and the trade between those. Would that be inclusive of having to be an MSB as far as Canada pertains?
That's a really good question, and I think, yeah, if there's a movement of funds, of cash, definitely that would apply. But as to the question, if it's just crypto to crypto, I think the act and those regulations may apply, and they may, yeah. Until we know the final verdict, until that legislation is finalized and published, which I think is going to be early next year. I don't know exactly, but my guess is the federal government would want to capture businesses who are interacting with Canadians in that way, even if it's just crypto to crypto. Yeah.
And just to tag on one extra thing there, how much do you think they're going to freak out when decentralized platforms that enable peer-to-peer swaps? So yeah, I'm excited about that too. But so there's going to be stuff they're going to be called atomic swaps. They've been demoed for so anybody unfamiliar. Essentially, what it does is it creates a smart contract between you and another individual that says, I will exchange this amount of, say, Bitcoin for this amount of Litecoin that you have, and I can allocate my Bitcoin to that contract, and it will sit there for a certain amount of time. If the correct amount of Litecoin shows up, it swaps and goes to the prospective owners of the new coins. If the other person does not send the coins, then after X amount of time, the Bitcoin reverts back to me. So I'm now no longer reliant on a business or a third party. It's person to person, and it's decentralized, and it can also be hard to trace because it's going to be on secondary layers that are onion routed. How do you deal with something like that? And I mean, I realize you're the one that's going to have to sort through the mess that happens once these laws come down, and then, oh hey, there's another layer to this.
Yeah.
What do you foresee, or how do you see them reacting to stuff like this? Because it always seems to me that we're drafting laws for the technology that existed a few years ago and ignoring what's happened recently.
Yeah. Yeah, that's a really good question, and I have heard of atomic swaps before. I guess one of the things I should mention is when you're dealing with FinTrack, which is the entity of the government that polices the anti-money laundering legislation, and when you're dealing with the Securities Commission, it's typically not until there's been a tip-off that someone is behaving badly or contrary to law that they get involved. So in the securities law context, if no one's lost money, the Securities Commission might never hear about it. In this case, what you're describing, it would be very difficult, I think, for them to actually enforce the laws if those kind of transactions are happening peer-to-peer. I love the peer-to-peer. I think that is the future, as opposed to the exchange platforms that we traditionally see. And I think it's going to be really challenging for the government to police that and to actually enforce that, because it would. Someone. There would have to be a tip-off, I'm assuming, to FinTrack, that there's an entity out there that's doing this. But if it's person to person, I think it becomes more difficult. It's probably why they've taken like 4 years plus to actually, like, since they announced that they were going to change the laws, to actually changing the laws. It'll be 5 years, I think, when it's all said and done. And I think they're grappling with these issues. And I haven't really turned my mind to things like atomic swaps and how how the pre-published changes are going to relate to that, to those types of activities. But like if you're if you're dealing in virtual currency, and there's the transfer of crypto to crypto. I think there's a risk that you could be conducting the activities of a money services. But I think it's mainly the broad-based exchanges, platforms that they're targeting, that have like thousands and thousands of users. But if you think about it, someone could launder money person to person pretty easily. But from what I see, I think they're after the large scale platforms, I would think, and then the ATM operators. Yeah.
And there was one other point that I saw later when we got into securities law, and the one that stuck out to me was if a token is finite. Now, what I was curious about surrounding that is you were saying, and I saw it a couple times up there, that hey, if a particular token or asset has been purposely made finite, then sometimes that's an excuse to pump up the price, and more often than not, it will be considered a security at that point. Are there exemptions for things like collectibles, and where does that line get blurred? Because then you can get into the issue of maybe right now, if I'm an artist and I'm painting pictures and I do a series of only 10 paintings, I mean, that's a purposeful thing because with scarcity comes value, if people find value in it at all. But now you can get into the idea of scarce digital art that is condoned by the artist. So you could have a digital file, and the file, the image itself isn't finite, but it's kind of like I can look at the Mona Lisa, or I can look at a postcard that has a picture of the Mona Lisa on it, and those are two very different things because one was created by the artist and condoned by the artist and vetted by them, and the other is just a copy so that I can see what it looks like. So when it gets into that kind of finite tokenization, where does that line get drawn, or what you've seen so far? Because there's levels to that, whereas it's digital art, or maybe it's a collectible card, or maybe there's a lot of different things in there, and where does that line start to blur when it comes to securities?
No, that's a really good question, and I think you would just take a common sense approach to that, right? And the regulators would it would be like the smell test. So what else is going on? Like, is it really a work of art that the person has created? Are they claiming something is a work of art when they've created 50,000 of them, and where it's the amount of ingenuity. Well, it could still be ingenuity. I was going to say is negligible, right? But so how are they promoting the art? Are they hyping it as though that this is a one-time thing and the sale's going to close? And I don't know. Like you'd have to look at what actions are being taken in conjunction with the development of it and with the sale, really. If something is truly a work of digital art, and the factors are there, and you could make the argument that it is in fact a work of art, and it passes a spell test, and that they're not trying to profit from it in the same way that they are if they're pumping up an ICO token. Then maybe the regulators would say, look, it's a work of art, it's legitimate, and case closed kind of thing. So yeah, but yeah.
Let's, if we can, let's take a few quick questions from the audience, and then we'll dive into the next one after that. So we're right here.
Sure. Here in Calgary, I've heard of a few companies separate the token issuing company and the actual application software development company itself. Is that a viable strategy, or is it because it's an arm length, you could still be in trouble anyway?
So what's the separation like again? You've got the company that's, maybe could you just repeat that?
Yeah, absolutely. So you have the company or the business that's trying to raise money, but because their token is considered a security, they launch it out of the Bahamas or something, and they just separate the actual issuer of the tokens from the Canadian company. Is that a viable strategy?
Do they sell to Canadians and Americans?
Yes.
If they sell to Canadians and Americans, and there's a significant connection of the directors and officers to Alberta, and it goes province by province, I would be concerned that the Alberta Securities Commission would consider it a distribution outside of Alberta, because of the significant connection, and therefore they would claim jurisdiction and look for compliance or non-compliance. Yeah. So the classic that I get is, yeah, we're doing this token offering, and we're not selling to Canadians and Americans. You know, we're going to do it offshore, Costa Rica, whatever. You know, can we do this? And the concern again, and that's the same issue, is if someone is resident in the province, you know, that could be a problem if they're the directing mind, if they've got a say in how the development is going, if they're calling the shots. You know, if 2 out of 3 of them are here, even if 1 is here, sometimes that can be an issue, and you just have to keep in mind that the commission is watching. Yeah, for sure.
I have a question. Just a quick question.
Yeah.
You talk about virtual currency. So the question to you is, what's the difference between the points? Because when you go buy some places, they give you points, and these points has a cash value. I understand it's mine, like $20 or whatever. So where in the law they define the difference between the points and the bonus points, and the token, which we are here interpret as a Bitcoin? Like, why the law seeing both? For me, both are the same. Mm-hmm. That's right.
Yeah. Yeah, I guess, you know, there's an entity usually behind the rewards, right? There's a credit card company or a bank, and so that credit card company, bank, is presumably complying with some level of legislation, and the reward points, you know, the offering of those rewards are probably done in connection with that compliance. So the difference here is that you don't have that primary level of compliance that's already existing. It's like someone's just coming up with something, you know, on their own and trading it or facilitating trading. And they're not a bank, and they're not a credit card company. They're not otherwise registered. Yeah.
Back here.
Regarding earlier statement, you mentioned 2 ERC or a few ERC20 tokens that are doing something interesting. Could you expand on that?
Well,
a bit more?
There was one I saw that was tied completely to a non-for-profit entity. There was no for-profit element whatsoever, and there's actually an exemption in securities law for like political parties and not-for-profit entities. So these guys structure, and you know, I mean, you know, my opinion was based on the assumption that that it was going to be set up as a bona fide non-for-profit, and this company had shown me that they had taken steps to do that, and also taken steps to register political parties. So that was really novel and unique. I hadn't seen that before. You know, I guess the, you know, my opinion on whether something is a security, it depends. Like if there's no ICO and there's like the native token that's on this platform that's already in existence and it's already got like nodes and master nodes running, and there's a good argument there that it might not be a security, and especially if it's got some practical use as well. You know, that helps. So. Yeah.
So you just said that there are certain exemptions for political parties. So how would that play? So I create a political party and I want to run for office wherever, and then I say I've then created some sort of a token for my political party, and there may be some sort of an exemption for me to list and sell that token because I'm in politics. Is that correct?
Well, it depends on how you're selling it, right? Like okay. Golf club memberships, right? Those could be considered securities because it's a membership to a club. You can trade it with other people, right? It has value, but there's an exemption for those types of things. A political party, you don't generally consider, you know, like a membership card that you buy or a membership that you buy in like the NDP or the Conservatives or Liberals to be a security. Like that's not something that's commonly known as a security. It's you know, your money is going in. There's Elections Canada is involved. You know, there's only a certain amount you can contribute. I think there's laws around that. Not that that doesn't make it a security, but you know, just generally speaking, if it's a bona fide political party and you're selling a membership and you're doing it, you know, and the membership happens to be a digital token, it might not be a security. Yeah.
Another one up here.
Just kind of curious, I saw something on the internet about, out of Malta, there's a big family trust symposium happening in 2019 in around Bitcoin, and how, can you talk a little bit about what that means in terms of trusts or family offices?
Well, yeah, so I guess, like, and I have spoken about this before, actually to a group of lawyers, wills and estates lawyers, about digital currency. And so I don't know if this relates to your question, but you know, like the way that trusts are set up, they're set up to deal with property, much like a will, and you know, the law reveres trusts. They're this mysterious, you know, creature that you know, the courts generally respect, and they don't pull them apart too much. The CRA will kind of audit from time to time, but the digital currency and you know, like Safecoin, for example, it's really interesting when you think about how wills are set up now and how trusts are set up, and how you deal with digital currency in those you know, in those kind of legal creations, because it's, you know, it's generally going to be difficult for someone to, for an executor, unless they're tech savvy, to, you know, even know that someone's got digital assets or know how to access them. And that's been an issue in wills and estates law, and so it's been recommended that people put specific clauses in their wills that appoint a digital asset executor who just is in charge of solely managing after death the deceased digital assets. And you can put a lot of different assets in a trust, and you can direct, if you're setting the trust up, exactly how you want those assets, who you want them to go to, how you want them used. And so, you know, digital assets, digital currency, obviously, are relevant for trusts. And so I think, you know, that conference and some of the thinking in trust, let's understand the technology a little bit better, and let's try to draft our trust indentures and our wills so that it's clear how we deal with our digital assets.
Yeah. Well, I think I'm gonna wrap it here so that we can get into the next presentation. But thank you so much. Let's give a big round of applause. And yeah, up next we got Burgoyne? Yeah, we do. Awesome. So thank you very much. And I'll get everything set up here. We're going to go pretty much right into it, just so we keep ourselves rolling here for the end of the day.
Yeah.